You have the court order, but do you understand what's behind it? Maybe you've been through court. Maybe you're trying to make sense of a decision that changed your family's future. Or maybe you're just starting your journey and want to know what to expect. Behind the orders isn't just about the what, it's about the why. In each episode, we break down real family court scenarios and unpack the reasoning behind the orders. You'll learn what principles guided the judge's thinking, what evidence made the biggest difference, what factors were weighed under the law, and what you can do to better prepare or respond. This is not legal advice, but it is a guided look behind the curtain, an educational series for self-represented litigants, law students, and anyone navigating the Family Court of Australia. Whether you're dealing with parenting matters, property division, or appeals, we help you see the thinking behind the orders, so you're not left guessing in the dark. Each video is short, focused, and designed to give you clarity. No jargon, no overwhelm, just insight. If you've ever thought, that order doesn't make sense to me, what did I do wrong? How do I prepare better next time? Then this series is for you. Subscribe to the series, watch one episode at a time, and take the guesswork out of one of the most emotional and complex journeys in law. This is Behind the Orders. Welcome to Episode 1 of the Federal Edition, Navigating the FCFCOA Family Law Maze. Facing family law matters can feel like stepping into a complex labyrinth, especially when you're representing yourself. But don't worry, you're not alone. Across Australia, except for Western Australia, family law matters are handled by the Federal Circuit and Family Court of Australia, or FCFCOA. This court has broad federal jurisdiction, covering family law, migration, fair work, and more. This means whether you're married or in a de facto relationship, your family law case will generally be heard under the Family Law Act, 1975, Commonwealth. Before you even think about court, you must attempt to resolve your dispute outside the courtroom. This isn't optional. It's a mandatory requirement designed to save you time, money, and emotional strain. For parenting matters, you'll generally need to try Family Dispute Resolution, or FDR, with an accredited practitioner. If you can't reach an agreement, you'll receive a Section 60I certificate, which you'll need to file with your court application. If FDR isn't applicable or fails, you must send a formal notice of intention to the other party. This letter outlines your issues, the orders you seek, and a genuine offer to settle. The other party then has at least 14 days to reply. A critical part of pre-action is the duty of disclosure. You must exchange all relevant financial information, bank statements, tax returns, superannuation, property details. This transparency is non-negotiable, and hiding information can severely prejudice your case. If there are allegations or risks of child abuse or family violence, you must also file a Form 4 Notice of Child Abuse, Family Violence, or Risk. To formally begin, you'll file a Form 1 Initiating Application. This single form is used for all family law matters, including divorce, parenting, property, and spousal maintenance. The FCFCOA website provides comprehensive kits to guide you through the necessary forms. Most court documents must be lodged through the Commonwealth Courts portal. You'll need to register for an account. This portal is your digital gateway to filing documents, tracking your case, and receiving court orders. After filing, you must serve copies of your application and all supporting documents on the other party. Initial applications typically require personal service, meaning someone over 18 who is not you physically hands the documents to the other person. The person who served the documents must then complete an affidavit of service, a sworn statement proving when and how service occurred. This must be filed with the court. Filing fees apply, but you may be entitled to a reduction or exemption if you meet specific criteria, such as receiving certain government benefits or experiencing financial hardship. Your first court date, often called the first court event, is usually about 1 to 2 months after filing. This is a procedural hearing where a judicial registrar will set directions for your case's progression. While your case is ongoing, you might need interim orders for urgent temporary arrangements, like child contact schedules or who pays the mortgage. These decisions are primarily based on the evidence in your filed affidavits, so make them thorough. For financial matters, the Conciliation Conference is a crucial settlement opportunity. A registrar will help you explore options and encourage genuine efforts to resolve the dispute. Attendance is compulsory, even if you have a legal representative. Throughout your case, directions hearings will occur to manage the timeline and flow. The judicial officer will make orders for further steps, like expert reports or mediation. Always ensure any documents you provide to the court are also shared with all other parties. The duty of disclosure is continuous. You must keep exchanging all relevant financial and child-related documents throughout the entire process. Failure to comply can lead to serious penalties, including costs orders or even your case being halted. Your primary evidence is your affidavit, a sworn statement of facts. It must be typed, divided into numbered paragraphs, and only include what you personally saw or heard. Avoid opinions or hearsay. Attach relevant documents as annexures. Be aware of page limits for affidavits. In Division 1 of the court, it's generally 25 pages and 10 annexures. In Division 2, it's 10 pages and 5 annexures, unless the court grants permission for more. Sometimes, expert reports from professionals like psychologists or valuers are needed. If you require information from third parties, use a subpoena, a formal court order compelling them to produce documents or give evidence. Be precise with your requests and aware of strict timeframes and fees. The trial is the formal event where all evidence is presented. You'll deliver an opening address, present your affidavit evidence, cross-examine the other party and their witnesses, and make a closing address. Remember, what's in your affidavit is crucial, as new information usually isn't allowed. At the trial's conclusion, the court will issue final orders, legally binding decisions that definitively resolve your family law matter. If you're unhappy with a decision, you can appeal, but it's not a rehearing. You must prove a significant error of law or fact by the original judicial officer. Appeals are highly technical, costly, and have strict time limits, generally 28 days from the date the order was made. Always seek legal advice immediately if considering one. You don't have to navigate this alone. Legal aid commissions across Australia offer duty lawyer services for urgent matters and specialist support. Community legal centers also provide free or low-cost legal advice and assistance. The FCF-COA website is an invaluable resource for handbooks, forms, and information. Remember, court staff can help you with procedures, but they cannot give legal advice. Be organized, prepared, honest, and polite in all your dealings. Your diligence is your greatest asset. Navigating the FCF-COA family law maze as a self-represented litigant is challenging, but with careful preparation, understanding your obligations, and utilizing available resources, you can confidently move forward towards a just resolution. Empower yourself with knowledge. This has been Episode 1, Federal Edition, of Behind the Orders. Subscribe for more insights into family court decisions and click on the link below to visit Brief Case for more help and insight. Until next time, watch out for what's behind the orders.